Good morning, your care is Antoine. And Mr. Antoine was previously in court, entered a plea of guilty to injury to a child, elderly, or disabled individual. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We have, Judge.
Yes, Your Honor.
Any additions, corrections, explanations?
Yes, Madam Judge. We do have, next, I was going over it with Mr. Antoine here, and I think the main issue was that a part of the allegation against him involved, I guess, hitting the child or whatever with a belt buckle. Mm-hmm. I think that's where he zeroed in on, not the overall picture of the whole circumstance.
Okay.
But he's more than willing to take accountability for what he did do, what he was guilty of. And I think also some of the statements in the PSI regarding his mental health history may kind of speak to that.
So I guess the question is taking responsibility for what part?
Both for disciplining her, and it may have gotten a little excessive, but not hitting her with a belt buckle or anything like that.
Okay.
Probation, or what he was trying to explain.
So hold on. All right, so you have 3 biological children, correct? And the victim in this case is not your biological child. And do you have any contact with her mom?
Yes, ma'am.
What kind of contact?
This my fiance, but like I said, last time I was here, everything has been supervised since this has been going on. I really haven't been, and the only time I see her, and I don't see the kids, so I
So who lives with you?
just my 1-year-old, like I said last time.
The mother of your 1-year-old, is that the same mother of?
Mariana. Yes, ma'am.
Okay. But y'all don't live together?
Judge, I believe at the last setting, when we actually did the plea, they weren't together at that time, weren't living, he had got his own place, that's why his child was with him.
Right.
And everything, so they're not together for his living, but I think they've started back in communication and things of that nature.
I guess I'm concerned about what that means in the future, because I don't want, well, it says no unsupervised contact. Anything else other than what the recommendations are, which is no unsupervised contact?
I mean, that's the whole point of it, is make sure the child's protected.
Right.
And if the court feels that's enough to maintain that, then I'm okay with that, Your Honor.
So here's another thing that I'm going to order, Mr. Antoine, if I go along with this, because obviously I have some concern about the level of discipline, whether it's your child, whether it's your stepchild, and now you have children with you. There are other ways to discipline other than putting your hands on a child.
Yes, ma'am. And I figured it out through time. I wouldn't
Even your own children,
yes, ma'am, I wouldn't even.
you cannot put your hands on your own children.
I wouldn't whoop a kid.
Okay.
This is my first time being in real trouble, and I don't get in trouble.
Your Honor, Ms. Gibson, the mother of the child, is in court if you wanted to hear from her.
Ms. Gibson, come up, please. Good morning. So, Ms. Gibson, you are the mother of Kimoriana, and also the baby. So y'all have one child together, correct? How many other children do you have other than Kimoriana? You have what?
5 altogether.
5 altogether. And where are all of your children?
My 1-year-old stays with him, and the other 4 stay with me.
Okay. Are y'all trying to work things out and get back together, or are y'all just co-parenting? I need to know for sure what's going on.
We're actually trying to work things out for the sake of our relationship with the kids as well.
Has Moriana had any unsupervised time with Mr. Antoine?
No, I'm always around.
And you understand that that's gonna be part of the order
Yes, ma'am.
of the court, and you can't say it's okay because he'll end up going to prison.
Yes.
So she can't give you permission to do something that I haven't given you permission to do. That makes sense? Okay. All right, thank you. You can have a seat.
Thank you.
All right, so I'm going to find, Mr. Antoine, that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That includes still having no unsupervised contact with Kimoriana. That is also going to be, you're ordered to enter and successfully complete a parenting course. It's offered through Faith Tabernacle Church. You need to get that done and started within 30 days, okay? It'll just help you to have better skills at being a parent, okay? You're going to be on the high medium caseload, and you're going to be assessed to see if there's any mental health needs or whatever you need. They're going to give you everything you need, the opportunity on probation to be able to be successful, make better decisions, be there for your children. The important thing is that you do everything that's asked of you, because if you do, this is an excellent opportunity, because you do not have a felony conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty, and you could go to prison for anywhere between 2 and up to 10 years. Do you understand? And I do want to make sure you understand, as a condition also of the probation, I am ordering that you not use corporal punishment, which is a punishment where you whip or place your hands on your child. Do you understand? Okay? If you'll just I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork. All right, good luck to you, sir.
Thank you, Your Honor.
Thank you. And thank you for being here, ma'am. Good morning, you're Renisha Chason? And this is 24 DCCR 2351. Ms. Chason was previously in court, entered a plea of guilty to injury to a child, elderly, or disabled individual. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have,
Are there any additions or corrections?
Just refresh the court's memory that the co-defendant, Kendrick Williams, in this case, was sentenced to quite a bit of pen time.
Okay.
And it's really my opinion, especially with Ms. Chason, taking responsibility, admitting her fault in the situation, having stayed clean on her drug patch for quite some time, that he was the most culpable of the actors. He was the drug dealer who obviously had the PCP that the child came in contact with.
Right.
So as long as she complies with any and all conditions that either CPS or the court would have regarding her being around children and caring for children.
Right. What is, I had a note here to ask, what's this current status with visitation and child protective service and all that?
I just know I got to keep my rights, and I'm just following my bond stipulations. I can't be around any children under 18, so
Okay.
once my case is closed, then it'll be up to Charlotte if I can see her, or, visitation rights will go by her.
Okay.
I still get
Who's
paid to
Charlotte?
keep Charlotte is Kendrick's aunt.
So she's the one who has custody?
Yes, ma'am, that's her grandmother's sister.
Okay, so anything would be through, is CPS still involved in all that?
No, it's been closed since May.
Okay, but she's the one who has primary custody, and it'll be any visitation with her?
Yes.
Okay. All right, anything else then?
No, Your Honor, I would look to dismiss the motion for those.
Okay, I'll sign that when it comes through. All right, Ms. Chason, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. Obviously, that means adhering to any rules that have to do with who has custody and visitation and things like that as well. You're already on probation, you know what it's all about, so you, hopefully we'll get past this. Looks like you've already done the parenting course and
Yes, ma'am.
completed the substance abuse, all of that through CPS, right? Okay, well, anything that probation feels like would be helpful for you, that you need to follow all of that, and if you do, this is again an excellent opportunity because you don't have the felony conviction on your record. And if you do everything correctly, the case will be dismissed at the end. The other side to that is if you violate any conditions, you'll be back here in court. And in this case, you could be looking at between 2 and 20 years in prison. Do you understand?
Yes.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over the paperwork.
Yes, ma'am. Thank you,
Is there, hey, hold on.
With respect to the drug patch, Judge, I didn't know your position on that. It is not my position that she continue to have to wear one. Maybe if she goes through JCDI to kind of get on the
Can I
right
see,
track.
Jody? Oh, here, I've got that. Let me look real quick at what the recommendation was. Yeah. I mean, it was a condition of your bond. It depends if probation feels,
Can we let probation determine that, Judge?
yeah, as of now, it doesn't appear to be a condition, but if probation feels like there's any issue with regular drug screening, JCDI is also not on here. So if you want to do a substance abuse evaluation, then I would be glad for that to happen, and for any treatment that that evaluation says needs to happen, then you would be required to do. So we'll get a new evaluation done. I know you've already gone through some treatment. Maybe that's enough. Maybe you need some more, whatever it is, probation will let you know. As of now, today, you don't have to have that drug patch, but it may be that after that evaluation, they want you to get it back on, and whatever they want you to do is what my order is. Okay? All right.
Will be excused then?
Yes, just have a seat. Yes, ma'am.
Miss Joseph said I can see my daughter. Can I see her today?
So as of today, the rules are whatever the family court or CPS set up
Yes, ma'am.
is going to be okay with me, as long as it's supervised with the great aunt, or,
Yes, ma'am.
yes, okay? As long as it's supervised, you can't go and take her anywhere until further order of any court, okay?
Yes, ma'am.
Okay,
Thank you.
yes, ma'am. See, you've got Jermaine Young. Good morning, you're Bonita Graham.
Yes, ma'am.
And Ms. Graham, you are on probation, obviously, for credit debit card abuse, and there's a new offense of credit debit card abuse. Ms. Holmes is asking for some additional time to discuss with you and Mr. Coleman what your options are in your cases. And she's also asked me if I would reconsider the bond condition requiring your GPS monitor. So you're still going to probation regularly like you're supposed to, correct? Are you working?
No, ma'am.
Okay. And so, Mr. Coleman, do you have any other information, recent information from probation that she's not doing what she's, as far as reporting?
No, Judge. No indication that she's otherwise violated that condition.
Okay, let me look at something else also. So this was already a straight probation. Because that was the second credit debit card abuse.
And then she's also on home confinement, except for you did give her some, location, like for her to be able to pick up her grandchild, because she takes care of her grandchild. So I know that there's restrictions on where she can and cannot go, included.
I just want to make sure that, Ms. Graham, you understand that a condition of your bond, if it was not already, is that you have absolutely no type of work, whether it is for income or not, taking care of anyone in their home, elderly, children, it doesn't matter to me. No home health stuff, no taking care of anyone, family or otherwise. Do you understand?
Yes, ma'am.
Hold on a second, let me look at one more thing. So that wasn't what the first one was anyway. That was just, what you're on probation for is just helping someone pick up their purse that dropped and taking a credit card and using it for yourself. And so let me look at the new offense probable cause. Okay, that really didn't have anything to do with what was going on. These are just offenses of opportunity in different places, it appears. So I'm not sure where that, is there any information that you have further on Mr. Coleman or the allegation of where or how the complaining witness, Miss Brittany Morgan's card ended up?
It was
My understanding
a
is
auto
that
body shop.
place of employment, right?
No, it was a auto body shop.
It was used at the auto body shop.
Well,
No.
she was working there.
The lady
Oh.
it was an employee at the auto body shop in which Miss Graham was getting her car fixed over there. And the allegation is that she went into the lady's purse
Well,
and
I-
I thought she was
So
working
are the
at
bond
Alabama.
that's,
the complainant worked at the auto
Yeah.
body shop.
Okay.
okay, so I guess, hold on, let me look at one more thing, because the bond conditions that are in place at this point is she's allowed to go to the grocery store, to church on Sunday, and transportation for her granddaughter as set out in the motion. No, I'm not going to modify that. Based on the history, you can continue wearing that GPS. I want to make sure that you're only going to the places that you're supposed to, because obviously if there's any opportunities that are afforded you with someone's belongings, you're going to take advantage of that, it appears. So no, I'll reset the case, and we'll see you back at the next court date. Stay in touch with Ms. Holmes. She'll let you know when you need to be back. Thank you. You're free to go.
The plan is to dismiss the the motion on the MTRP, continue her on probation with a concurrent probation on a misdemeanor assault,
Okay,
as opposed to the felony assault. We're going to proceed on this one.
so there would be a dismissal of the motion.
Yes, ma'am, she'll already be there.
Okay, got it. And then I'll need this attachment today, because the case, it'll get closed out, and then you won't have access to
I'll
it.
do it before I leave.
Okay. All right, ma'am. Again, you're Kaylin Salzar, and let me get this pulled up properly. Will your client waive the formal reading of the indictment?
So moved. You're pleading to a misdemeanor assault.
And Ms. Salzar, the state has elected to proceed on the lesser included offense in cause number 25 DCCR 0503. It charges you with the lesser Class A misdemeanor assault from March 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimball? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached, as soon as this tablet decides to do something. Let's see, the agreement is for a 1-year term in the Jefferson County Jail, but that would be probated. You'd be on probation for 2 years. You would be ordered to pay a $250 fine. I would continue your probation in cause number 24 DCCR 2234. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Salazar is not competent?
I'm not aware, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser offense of a Class A misdemeanor assault, sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail, but that'll be probated for 2 years. You're ordered to pay the $250 fine and to follow all of the rules and conditions of probation. If you do that, then this is a great opportunity because for all practical purposes, you will serve this time while you're out on probation. The other side of that, though, is if you violate any condition, you'll be brought back in and you'll be looking at revocations in both cases. And in this case, looking at going to the Jefferson County Jail for that 1 year that you've agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am.
Thanks, Judge.
Thank you.
Richard Raw.
All right, sir, again, you're Richard Robb. And will your client waive the formal reading of the indictment?
So,
Y'all are going on lesser?
yes, ma'am. I understand. Mr. Nichols, answer that.
I can't understand you.
I said, I'm sorry, I'll let Mr. Nichols answer that.
No, that's okay. I'm just trying to, I gotta pull it up differently. I don't even see.
Ralph, what was y'all's agreement?
3 days, spread it for 1 day, he's gonna go in.
Did we already?
Judge, it was going to be a reduction, I think, in JP court, and that didn't work out. It was going to be reduced no matter what, and I think they've agreed on, so this would be to a misdemeanor.
Class A.
Okay, so, hey, Kel, I did previously back in September, here's the original, I did this one, but now I need to do another.
Okay.
So which one should I,
Did you do anything on that one? You never did?
let me see if I wrote anything on it.
Well, just to be safe, copy that one.
I did not, so that's a good one. Okay, let me go back and do that then.
He's gonna need to report back up here for sentencing.
Yeah. Next week or the week after?
I think he wants the week after.
I'm sorry.
He wants the week after,
So Monday the 15th.
that's fine.
All right, Mr. Rob, in cause number 24, DCCR 2170, the state has elected to proceed on the lesser included offense of a theft between $750 and $2,500, which is a Class A misdemeanor, and that's from September 1st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimball? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, then you'll be waiving or giving up any right to appeal? And the agreement's for 3 days in the Jefferson County Jail, and it sounds like you have maybe 1 day credit, and so the agreement everybody's talked about is for you to come back on Monday the 15th. I would sentence you on that day. You would go with the bailiff that day, so you need to be prepared to have somebody drive you here. And then you might have 1 night because they'll do the 2 for 1, and then you would be done. Is that your understanding? I do want to make sure you understand, if you do not show up for court on the 15th, that this will be rejected and you're not going to get this kind of deal. You understand?
You could have bonds up and follow, you know, so.
Yeah, it could be another felony as well.
And then my belongings back to you, versus
Yeah, they'll take that to jail on your property when you're released from jail. They'll give it to you.
Yeah, you'll go with what you've got on.
Original arrest, I mean.
Yeah,
Oh,
yeah, yeah.
your original arrest?
We should have given you that when you moved on.
Y'all can talk about that later.
Okay.
And are you a U.S. citizen?
Yes, ma'am.
All right, state tenders number
No
one.
objection.
It's admitted. Any evidence that Mr. Rob is not competent?
None that I'm aware of, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to Monday the 15th at 9 o'clock. Just make sure, I don't need a pre-sentence report. Just make sure you're here on time and ready to go get that taken care of. Okay, we'll see you back then.
Thank you.
Good morning, sir. You're John Van Wright?
Yes, ma'am.
And will your client waive the formal reading of the motion and the indictment?
Yes, Judge.
Mr. Van Wright, in cause number 24 DCCR 2485, you're charged with, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of injury to an elderly individual from November 14th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have, in that case, some documents here on the tablet that have your signature on them that the state's marked as exhibit number one. Before you sign these, did you go over them with, sorry, I just went blank, Mr. Mitchell. I was going to say Mr. Brennan. It's like I knew that wasn't right. With Mr. Mitchell. And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you're waiving or giving up any right to appeal?
Yes.
And so y'all have marked off a fine also. Is he paying a fine and 2 years in prison?
On the new case, yes, Judge.
It should just be a $500 fine on the new case itself, not the MTR.
Okay, so when's that gonna get paid?
Can you pay that before the 15th?
I mean, if he's going to prison, what's the,
We always did a fine and prison time. But
okay, that's
we can
fine.
scratch off.
So, no, I just, whatever.
I'm good with scratching it off, Judge. It's fine.
Well, y'all agree to it, so you understand that the agreement is for a 2-year term in prison, a $500 fine. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And I thought you had said 4.
Further negotiations, Judge. I did clear it with the victim before. He's
Okay,
upstairs, but he was okay
he was,
with it. Yes,
with the 2?
with two.
Okay, thank you. All right, state tenders number 1,
No objection, Judge.
is there any, it's admitted, is there any evidence that Mr. Van Wright is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to Monday, December 15th at 9 o'clock. You'll need to report back here. I'll go through sentencing on that date. It's very important. Well, let's go through the other case and then we'll talk about consequences of not getting here. Let me see this. And then, so in cause number 15-23582, we were previously here and Mr. Van Wright had entered a plea of not true to allegation number 1. Is it my understanding that he wants to change his plea to that allegation?
Yes, Judge.
Let me get that pulled up again. So on probation for injury to a disabled individual, and count 1 alleges that you committed the offense of injury to an elderly individual, the case that we just went through, and is that true or not true? Are you entering your plea of true freely and voluntarily? And because that count is actually true. I also have some documents here on the tablet in that case that have your signature on them that the state's marked as exhibit number 1. Did you also sign these with Mr. Mitchell? And do you fully understand them? And again, you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal. State tenders number 1 in that case.
No objection, Judge.
It's admitted. All right, so I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation, but I'm going to, again, reset your case for sentencing till Monday the 15th at 9 a.m. It is, again, very important that you're here and on time. If for any reason you're not, then you run the risk of me not accepting these plea agreements, and things could be much worse. Do you understand? All right, then obviously I don't need any kind of pre-sentence report or update as well, and we will see you back on the 15th. Okay, thank you.
Do I need to still see my probation officer?
Between now, no.
No.
Thank you, Judge.
Thank you.
Appreciate it.
I mean, I don't guess there's any reason for that for 2 weeks if you're getting revoked. James Boswell. Good morning, sir. You're James Boswell. And this is cause numbers 25 DCCR 0992 and 0993. Mr. Boswell was previously in court, entered pleas of guilty in each of those cases, and I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
Not from the defense, Your Honor.
All right, Mr. Boswell, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. In cause number 25, DCCR 0992, find sufficient evidence to find you guilty. However, I'm going to follow the agreement and defer all proceedings and place you on probation for 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 25, DCCR 0993, I'm also going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years and order you pay a $500 fine. In addition to those requirements, I am also going to order that you are not allowed to possess any firearm at all. If you still have firearms in your home, then they need to be removed within 24 hours. They took them all? Okay. This whole situation and how you're treating people that live around you, the racial issues that are going on is ridiculous. And so you need to do whatever. If you go to work, come home. But all this interaction in the way that you have interacted with the people that live around you and what you did to these young kids probably scared them to death. And you're here, lucky you're not here for murder. You're lucky that I'm going along with this agreement because I don't really like it. I don't like what you did. I don't like how you treated those people, and I don't like what you did to those children. And it's going to stop, or you're going to end up in prison. There will be no, I made a little mistake and let me stay on probation, or let me go to some middle of the ground, ISF or something. If you make a mistake on this probation, you will be going to prison. And in these cases, you can go between 2 years and up to 20 years. Do you understand? Part of this is you'll be on the high medium caseload, and you're going to go through an assessment for any type of mental health treatment that you need. And if they say you need something, then you're ordered to do whatever it is that assessment says. That's in order to help you so that you can make better decisions and take care of this probation while you're out on the streets instead of going to prison. Does that make sense? All right, I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed and you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over all of your paperwork. Go have a seat. Good morning, sir. Are you Sean Dage? And Mr. Dage, this is your initial appearance in cause number 24, DCCR 2353. You're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from October 20th of 2024. Your indictment alleges a couple of other prior state jail felonies back from 2011, it looks like. So since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So when you were in jail, we automatically give you a court-appointed lawyer, but now that you've bonded out, I'm going to expect you to try to hire your own lawyer. So what I'll do is reset your case about 30 days or so to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you step in front of the clerk right here, she'll give you your reset notice. Good morning. Are you a Chason Howard? Aston Hayward, sorry, I said that all wrong. And Mr. Hayward, this is your initial appearance in cause number 25 DCCR 1346. You're charged with the state jail felony offense of burglary of a building from August 29th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, how old are you?
17.
Are you still in school?
Yes, ma'am.
Where do you go to school?
Woodford.
Okay, and you're currently attending school right now?
Yes, ma'am.
All right, so if you are unable to hire an attorney because you're still in school, you qualify for a court-appointed lawyer. Do you want me to give you a court-appointed lawyer, or is your family going to help you hire someone?
Yes, ma'am. Of course, ma'am.
Okay, all right, if you will, you ready? Step in front of the clerk, she'll give you that information. Good morning, are you Carisha Mays? And Ms. Mays, this is your initial appearance in cause number 25 DCCR 1464. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from September 26th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? I'm sorry, answer out loud. So, are you working? Why not? Okay, so here's what I'm going to do. I'm going to reset your case for about 30 days to give you some time to get a job. So you need to get a job and bring me proof that you have a job, or you need to bring me proof that you have applied to at least 5 jobs a week when you come back, okay? In the meantime, also, I expect you to try to be at least talking to attorneys so that when you get a job, you will be able to at least try to hire one. So you also need to talk to at least 3 lawyers between now and then, see what they cost, talk to more if you need to. They all charge different amounts, have different plans to pay and all of that. Bring me at least the 3 names, if not more, and the information about your job, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. Good morning, are you Erin Riley? And Ms. Riley, this is your initial appearance in cause number 25 DCCR 1194. You're charged with the third-degree felony offense of assault on hospital personnel from July 23rd of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So are you working? Why not?
I'm just mentally disabled.
I'm sorry?
I'm mentally disabled.
Do you receive disability?
Yes, well, I'm about to start. I have an appointment tomorrow.
Okay, so here's what I'm going to do. I'm going to reset your case for 30 days. You need to bring documentation of whether you've qualified or not. If you have, obviously you would qualify for a court-appointed lawyer. If you're not going to qualify and they deny you, then you need to be working on getting a job. Bring me information about where you've been trying to get a job, and then we'll discuss your options.
Yes, ma'am.
All right, step in front of the clerk. And also, if you don't bring that information that I've asked for, you run the risk of me raising your bond for not following the court order.
What
And
kind of proof do you need, like for the SSI?
just whatever they give you.
Okay.
Yeah, they should give you something that says you've, good morning, are you Devon Trey Johnson? And Mr. Johnson, in cause number 25 DCCR 0438, this is your initial appearance. You're charged with a second-degree felony offense of failure to comply with sex offender registration requirements from March 3rd of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so I'm going to reset your case about 30 days to give you some time to try to get someone hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then you run the risk of me raising your bond when you come back for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you that reset notice. All right, Ms. Payne, this is your initial appearance in cause number 25 DCCR 1142. You're charged with a state jail felony offense of criminal mischief from July 19th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? I'm sorry?
I didn't know I had to.
Sure. And so what I'll do, how old are you? Okay, so what I'm gonna do, Ms. Payne, is reset your case about 30 days to give you some time to hire somebody. If you get a lawyer hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, if you step in front of the clerk right here, she'll give you your reset notice. Good morning, you're Presley Biltz. Mr. Biltz, did you get someone hired?
No, ma'am, I'm still working on it.
Who'd you talk to?
Johnson, Crenshaw, Lawful, and Johnson, Gregory Johnson,
Who?
Gregory
Oh, Brevin Johnson. And Crenshaw, and who else?
Johnson.
Who's, you already,
But I still,
if you don't know, then how am I supposed to know?
I still talk to Livingston, that's why I was planning on going with
Who?
Livingston.
Livingston?
Yes, ma'am.
Is he here locally or somewhere else?
That's what I told you last time.
Langston Adams?
Yeah, Langston, I'm sorry.
Okay, you've been coming for a long time. Why haven't you gotten someone hired yet? Are you working?
Yes.
Where are you working? Full-time? All right, so I'm gonna have you fill out some paperwork. Thank you for talking to those attorneys. You need to fill this paperwork out this morning accurately and completely. Don't leave it blank. If it doesn't apply, write something in, and then I'll take a look at it. All right, step in front of the clerk down there, and she'll give you that paperwork. Good morning, you're Kingston Walker?
Yes, ma'am.
Mr. Walker, did you get someone hired?
Yes, ma'am. Well, I spoke, you told me to come back with either 3 lawyers or have somebody in mind that I'm hiring. I spoke with Mr. Nathan Reynolds and Mr. Langston Adams and Mr. Benjamin Hermes.
Jeffries?
Yes, ma'am.
Uh-huh.
But I did an office visit with Mr. Bird Ranks and we discussed the payment plan. And today I'll have the money to pay.
Okay, great. So what I'll do is reset your case to give you some time to get that taken care of. Make sure you bring the reset notice that you get to Mr. Burbank, and then he'll tell you what to do. If for some reason that's not going to work out, then make sure you talk to some others and see what you can get worked out before that next court date. All right, thank you. Step in front of the clerk right here. Good morning. Is it Jorge Quezada?
Yes, ma'am.
And Mr. Quezada, this is your initial appearance in cause number 25 DCCR 1472. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon from September 28th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I talked to a lawyer, but, what he's asking for, I don't have exactly
Sure.
part of it, so I was gonna ask for an extension so I could.
Yeah. So what I'll do is I'm going to give you a normal reset. It's about 30 days. It's probably a little more because of the holidays, to give you some time to get someone hired. If you do get a lawyer hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, if you step in front of the clerk, she'll give you your reset notice. Good morning, ma'am. You're Kyra Rogers. And Ms. Rogers, were you able to get someone hired?
No, but I did look up some names for you, and the pricing that they had gave me, like, that was too high for my job.
Who'd you talk to?
I talked to Douglas Sykes, Benjamin Jeffrey, and Marshall Long.
Okay,
But they had one like a big down payment at once, and they didn't want to work out like no payment plan.
right. Where are you working?
McDonald's.
Okay, so what I'm going to do this morning is have you fill out some paperwork to see if you qualify for a court-appointed lawyer. And so make sure you fill it out accurately and completely. Don't just leave things blank, write something in there or marks, and then I'll take a look at it after you do that and see if you qualify for a court-appointed. If you'll step in front of the clerk, she'll give you, thank you for doing what I asked you to do. Good morning, are you Darian Broussard? And Mr. Broussard, this is your initial appearance in cause number 25 DCCR 1441. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from September 23rd of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'll do, Mr. Broussard, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. Good, you're Brandale Griffin? And did you get someone hired, Mr. Griffin?
No, ma'am, I went to James Macon.
Uh-huh.
And I saw the 3 lawyers up in there, Sonny Echo.
I can't hear you.
I went to see James Macon, Sonny Eckhart, and another one, they all in the same building.
Uh-huh.
I don't think he put his name on it. I don't think he put his name on here though, but
Okay.
he was all charging the price I couldn't pay.
Okay, you didn't try anybody that was outside that same firm? Are you working?
Yes, ma'am.
Where are you working?
Focus Care, some place in nursing home.
Okay, so what I'll do, I appreciate you, I'm gonna give you one more reset to go visit with some other attorneys. You need to try to see if you can get someone hired before that next court date. I know you've only been here, it looks like once, but your case is very old for some reason, so we need to get it moving. So if you'll just try to get someone hired, if not, talk to 3 more, and then we'll discuss your options if you do all that and still can't hire someone when you come back.
Is this case against the state or against that person? Did the state pick up this case off?
Yeah, that's how it works. So the state, the case is titled The State of Texas versus you. And so that whoever it is the complaining witness in the case, but the state or the district attorney's office, God bless you, the grand jury indicted you. So whatever evidence they heard, they decided it was enough to bring it to court, and so that's why we're here. Okay, step in front of the clerk. Good morning, are you Mark Marceau? And Mr. Marceau, this is your initial appearance, can you hear me? Okay, this is your initial appearance in cause number 25 DCCR. Can you turn your radio down, ma'am? This is your initial appearance in cause number 25 DCCR 1413. You're charged with aggravated sexual assault on a child younger than 14, a first-degree felony from September 9th of 2025. Since you made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am. Don't have the job or anything. All I have is Social Security coming in.
How much do you receive a month?
$3, $4.
Okay. So what I'm going to do, I'm going to reset your case, a shorter reset than normal. You need to bring me some documentation of how much you receive, and then I'll discuss your options with getting a court-appointed lawyer. But you need to bring that documentation from Social Security. You understand? All right, step in front of the clerk. She'll give you that reset notice, and if you'll just write that on there, please, ma'am. Here's Shannon Stott. Oh, my goodness. And Ms. Stott, you were previously here. Did you get a lawyer hired?
I did not, but I did talk to 3 different lawyers.
Who'd you talk to?
I talked to Nolan LeBlanc, he is $2,500. I talked to Chadwick Robinson, he is $3,500, and Michael Hart, he's $7,500.
Okay. And where are you on being able to get someone hired?
I am a state for breast cancer patient, I'm fully disabled, and I do work part-time, so I'm still paying on my bond. So.
Do you have documentation of your disability? Okay.
Yes,
So.
I do work a part-time job too.
Okay. So let's do this. I'm gonna have you fill out some paperwork this morning. Put all that different, what the income is, where it comes from on that, any bills you have, and then I'll take a look at it. Thank you for doing what I asked. Also, I'm not sure what happened. You made you were bonded out of county, right?
Yes,
Okay.
She gave me the information
to get your fingerprints.
Yes,
You're okay. You need to do that before that next court date. It's very important.
Yes,
All right. If you will step in front of the clerk, she's going to give you that paperwork to fill out for me.
Appreciate it, thank you.
I don't see any note or any recent note regarding that.
I don't see any. Oh, so we were waiting on DNA. I see back in June, and I did a 60-day reset back then. So Mr. Hoffpower should have been looking into
There's an
this.
email from that time frame when he's discussing it with the detective.
All right, I'm gonna do another reset. Mr. Nichols, if you will make a large note on that file for Mr. Hoffpower to follow through
Yes,
with,
sure.
getting that done so that we know where we are.
Certainly.
Thanks. All right, stay in touch with Mr. Burbank. He'll let you know when you need to be back. Yes, sir, thank you. Mr. Comerford, on Farrell Gilbert.
He's present.
All right, sir, this is 25 DCCR 1009. You're charged with driving while intoxicated, third or more, and what is the announcement?
I need some more time to review some media discovery of Mr. Gilbert. I've received an offer. We've conveyed it to him, and so I'm just trying to negotiate some more and see if we can come up to a resolution.
Sure. And you've received all of the media and everything. So we'll just do a normal reset. Make sure you make an appointment, go visit with Mr. Comerford before the next court date so that you guys can go over all of the information and discovery that he's received, and we'll get an announcement at the next court date. Any issues, Mr. Smith? All right, you're free to go. Thank you.
Thank you, Judge.
You're Carolyn Whitaker. And Ms. Whitaker's cases are set for trial to begin with jury selection next Monday, the 8th. And what is the announcement?
Your Judge, I spoke with Mr. Morian already about this case this morning. There's a report he does not have. So I told him we'll run it down and figure out where it is, if it exists, and so get it to him. So we're asking for a reset.
Is there any anticipation that that report would change it needing to be on the trial docket, or it's just the information, documentation you need?
Your Honor, it's a lab report. This is a case with a charge of sexual in nature, and I believe that there's so many different ways that this could go on that one. And I believe it's maybe a dispositive type of report.
So what I'm gonna do then is I'll do a much shorter, just a normal reset, about 30 days, 40 days or so with the holidays, give you some time to get that.
I'll make a large note on the file.
Make a large note on the front of the file. No, you're here, you're gonna do it.
I sent over a letter on that too, so. it should be
But
in
that'll
file.
give y'all some time, and I'm just gonna place it on a review docket.
Thank you, Judge.
So if it is dispositive and it takes care of the case on that day, great. If not, we can put it back on the trial docket at that point.
Thank you, Your Honor.
Thank you. Stay in touch with Mr. Morgan. He'll let you know when you need to be back.
Thank you, Judge.
Have a good day.
May I be excused?
Yes, have a
Thank you
great
very much.
holiday. Good morning. Are you Blaine Dunnigan? And this is 25 DCCR 0566. Mr. Dunnigan's charged with driving while intoxicated, third or more. Mr. Gertz, what is the announcement?
Judge, we're still working through discovery on this case. We'd ask for just a normal reset, please.
Okay, any issues? Mr. Smith, any issues? No, okay. All right, Mr. Dunnigan, I'm going to, and do you have that auto ignition interlock device on your vehicle? All right, just make sure you keep that on and working at all times. I'll do a normal reset. Make sure you stay in touch with Mr. Gertz. You guys can visit about the case, and we'll see if we can get an announcement. All right, you're free to go. And then Frank Collins, you have sweatpants on? You think that's appropriate to wear to felony court? You don't have any clothes? Where do you live? With your aunt? How old are you? Are you working? Why? How much? $9.75? If I test you today, you gonna have anything in your system? Yeah, have a seat in the jury box. Good morning, ma'am. Are you Edmund A. Latulis? Stand up, please. And Ms. Latulis, you were previously in court, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, I have, Your Honor.
Any additions or corrections?
Nothing defend.
Nothing from the state.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 5 years. Order that you pay the $300 fine and to follow any rules and conditions of probation. Part of those rules and conditions is that you attend grief counseling. I don't know if you've already started that. You can talk to probation about where you can do that. It's very important because of what happened that you don't allow the grief of that to make you kind of go down the wrong path. You need to be there for your other children. I want you to be successful on this probation, and that's part of the reason that that's going to be ordered, is to help you, okay? If you do everything you're supposed to while you're on this probation, this is an excellent opportunity, and I have no doubt that you will. because you don't have a felony conviction on your record. And if you successfully complete it, the case gets dismissed at the end. The other side of that, though, is if you do violate any condition of probation, you can be brought back into court. You could be found guilty of the offense and go to the state jail prison for up to 2 years. Do you understand? I am handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk to go over your paperwork in just a few minutes. Good luck to you, ma'am.
Thank you, Your Honor.
And Anthony Salvato. Good morning, you're Anthony Salvato. And Mr. Salvato has a motion to revoke probation. What is the announcement?
Judge, I have spoken at length with his probation officer about how well he is doing. I've also received further documentation from the sober living facility run by veterans in Houston that he is participating in. I think he's doing extremely well. He's gotten on the right track.
Good.
And so we would like the court to consider allowing his probation to just go ahead and expire out on the 15th of this month. Allow him to continue with those services and his employment through that. He's done
Okay,
great.
so that's great to hear. So you'll be filing a motion to dismiss that motion then?
Yes.
Okay, so it sounds like you're well on the right path. Continue that even when you're not on probation and don't have to.
I intend to stay where I'm at, as a permanent resident.
Good, all right. Well, good luck to you, sir.
Thank you.
Thank you.
Thank you, Ms. Holmes. Thank you, Ms. Muffino.
Thank you.
All right, sir, you're Rafael Glover. And this is 24 DCCR 0232. Mr. Glover's case is set for trial to begin with jury selection next week. And what is the announcement?
State's ready, right?
Tell him to shush. Mr. Kimmler, ready? And has there been any additional negotiations or anything like that?
No, Your Honor.
All right, I do want to make sure you understand, Mr. Glover, I will number the cases after docket tomorrow. There will not be any plea agreements accepted after tomorrow at noon. Do you understand? Okay, I will number the case. Stay in touch with Mr. Kimmler. He'll let you know when you need to be back next week. All right, you're free to go. And then you've got Johnny Polanco. Okay.
Brought it to us last week.
Uh-huh.
So we just need time to get it done.
So I need to put it on a review, take it off the trial docket. All right, so I'm going to move Mr. Polanco's case to a review docket in about 45 days to give the state time to get whatever else done or filed on any new offense, and that'll give you some time to try to get up to speed, and we'll get an announcement at the next court date. Stay in touch with Mr. Kimmler. He'll let you know when you need to be back. And if you'll make a notation on that their feds didn't take a case, so they're going to do it here. A new case, yes. Kaylin Salzar, and did you already send that paperwork on Salzar?
Yeah, I sent it to Tom.
Okay,
He's gotta dismiss the MTRP.
that's fine, Mr. Coleman, y'all still working on paperwork on Salzar?
Yes, Judge, I'm doing it right now.
Okay, thanks. All right, so are you Richard Robb?
Yes, ma'am.
And this is 24 DCCR 2170. Mr. Robb is charged with theft of property, and what is the announcement?
Your Honor, I think the state and we've reached an agreement where Mr. Robb will take a plea of 3 days county on misdemeanor reduction, or lesser included, but he needs, I guess, some time to, he's got a day credit, so I don't know how that would handle it over the jail. He may have to do a day. So I would ask him, when can you do that? Let me hold it for a second.
Okay, I'll hold it, because if we're gonna get it taken care of, we can do it next week before the end of the year. See, this is Mr. Hoffpowers. Thank you. So when's the last time you smoked marijuana? Last night? You thought that was a great idea to smoke marijuana the day before you were coming into court?
Judge, you're gonna wanna read the back of his hoodie.
Turn around. Turn back around.
These the only clothes I got now, like,
Well, maybe if you weren't spending money on drugs, you'd have some money to go, you can go to Goodwill and buy a new shirt for $5, for $2. So I'm not buying that that's all you have. And if it is all you have, then that's a choice that you're making. I'm going to find that you violated the condition of your bond. The fact that you smoked marijuana last night is absolutely ridiculous. You're making terrible decisions, and there's nothing I can do today because you could still be under the influence. And so we're not going to go through any paperwork and take any plea deals while I think you might be under the influence. So to make sure that you're not under the influence next time you come to court, I'm going to raise your bond in your case to $50,000. A condition of that bond, if you make it, is to have a drug patch on at all times. And you can go back with the bailiff. We'll reset the case. I'll reset it for the final docket of the year, which will be that Tuesday, the 16th. All right, so he doesn't have to wait the whole time, and we'll see how things go at that time.